Judges of the United States Court of Appeals for the 10th Circuit. Hear ye, hear ye, hear ye. The United States Court of Appeals for the 10th Circuit is now in session. All those having business before this honorable court may now draw near, and they will be heard. God save the United States and this honorable court.
Please be seated. Good morning. We have 6 cases on the docket today, and we'll probably take a break after the third argument, see how things go. With me today is Judge Ide from Denver, Judge Carlson from Roswell, New Mexico. We're glad you're here. Stock show weather is dropping in, as it always does, so I hope you're going home after the argument today. All right, so let's get started. The first case is 25-9531, Ute Indian Tribe versus EPA. Mr. Holditch, you may proceed.
May it please the court. Good morning, Your Honors. My name is Michael Holditch. I am appearing on behalf of the appellant, the Ute Indian Tribe. I'm joined by my co-counsel and colleague, Mr. Jeffrey Rasmussen. Your Honor, this case revolves around a 500 megawatt coal-fired power plant electric generation unit, the only one of its kind, located not near, not around, but on the reservation homeland of the appellant, the Ute Indian Tribe. The Bonanza power plant emits nitrogen oxides, sulfur dioxides, particulate matters, and other known pollutants directly into tribal airspace. For around 15 years, from around 2000 to 2015, emitted these pollutants into tribal airspace without the controls, conditions, or limitations of a Title V operating permit as required by the the United States Clean Air Act. The air quality impacts that resulted from these unbridled emissions have never been meaningfully addressed, mitigated, or studied. The United States Environmental Protection Agency stood by for a decade and a half and allowed these unbridled emissions, only to subsequently issue and now renew a Title V operating permit as if nothing had ever happened. So at its core, this is not a case about forcing an operator to comply with air quality standards, nor is this a case to antagonize producers engaged in fossil fuel production on the Uinta Reservation. What this is a case is about EPA and its failure to uphold its unique government-to-government relationship with the Ute Indian Tribe, which is defined not only by the exacting fiduciary standards of a trustee, but also as by their mutual relationship as sovereigns with concurrent jurisdiction over the lands and airspace.
If you wanted to challenge the efficacy of the pollution control measures that EPA approved, is there another form or another way to do that? You're not really making a direct attack on, whether they're adequately protecting the health and safety of the people that live near it. You're attacking basically the process that was used. Is there a substantive case that you have somewhere where you've challenged that?
There's no substantive case right now challenging directly the adequacy of the control measures. What we're challenging here, Your Honor, is the adequacy of the assurances that have been provided to the tribe, whether that's through studies or data provided, that these control measures actually do what they're supposed to do.
Let me stop you for a minute. I don't think that was responsive. I think what the judge was asking you was if there was another forum where you could get relief, another avenue, like challenging the permit or something like that.
Yes, you could challenge the permit itself for the adequacy of the control measures, whether that's through a violation of the permit itself, through a citizen suit provision under the Clean Air Act, or through a separate APA action that's, slightly different in nature and character from the current one, in which there would be a direct challenge to, the sufficiency of the controls, where we say this control is not sufficient and here's why. But this case is more focused on the EPA and its abject failure to uphold its requirements vis-a-vis its government-to-government relationship with the tribe. So here EPA's approval of the Title V permit renewal can be broken down into two salient shortcomings. First, EPA failed to engage in meaningful government-to-government consultation in compliance with its own tribal consultation policy. And second, EPA failed to consider all relevant factors when issuing its approval, including factors pertinent to the best interests of the tribe pursuant to its trust responsibility and relationship, rendering EPA's decision arbitrary and capricious under the APA standard.
Well, the record does disclose there was some consultation. Where do you think there's kind of a line drawing exercise that we have here, where, how much is enough under the EPA's policy guidance? What was the specific failure here?
So the specific, there's a few specific failures here. One is simply that we have a 92-page Title V permit, and there was a grand total aggregate of less than 2 hours of government-to-government consultation. Now we are not, as I think the briefing makes clear, we're not trying to draw a bright line of, does this issue require 2 hours versus this level of complexity requires 3 hours, 4 hours, et cetera. It's not a time-based test, it's a functionality test. So we know that the consultation was deficient and cursory because the legitimate questions and concerns that were raised by the tribe during this consultation process were never meaningfully addressed. And those include things like, how does this SCR, selective catalytic reduction technology, and I'm talking from a lay perspective now, that's the technology that once installed is supposed to function to lift the lifetime cap, or the cap on coal combustion at the facility and allow coal consumption indefinitely. What studies and what scope of that technology provides the assurances necessary that indefinite coal consumption at this location on the tribe's reservation will not result in localized adverse air quality impacts, things like that. As well, and that's kind of a forward-looking example. As a backward-looking example, the tribe had requested, consideration of what controls could be put in place or measures could be put in place to offset the 15-plus years of unbridled emissions that took place on the tribe's reservation as a result of EPA's failure to establish those control measures
Before you get to
required to.
the substantive aspects of the consultation, don't our cases generally say that a policy guidance document is not legally binding on the agency? And we have a couple cases in the briefs that stand for that proposition. Why is this policy guidance legally binding as opposed to the general rule that they are not?
So that's a fantastic question, Your Honor, and I think the title of this agency document as a policy can be misleading, but really the distinction here is between a general policy statement and a procedure that impacts the public. So under 10th Circuit case law, the agency is required to follow its own procedures, especially when those procedures directly impact the public or individual rights. Here we're talking about the rights of the sovereign Ute Indian tribe to provide meaningful input and have that input considered in a real way. So I think a key illustrative.
What's the case that is the best support for that proposition?
I think the best case would be actually the U.S. Supreme Court case in Morton versus Ruiz, because that sets a good illustrative point of distinction between the primary case that the EPA has cited, which is the AMREP Corp case. In the Morton versus Ruiz case, the Supreme Court found that there was an agency procedure in place, and this deals with Indian tribal issues as well, where any departure from or determination relating to the eligibility requirement of enrolled tribal members for general assistance program funding required, a certain procedures, publication, things like that. Their departure from that standard without any rational explanation rendered the agency action arbitrary and capricious.
Wasn't the policy there after notice and comment and traditional rulemaking?
I don't believe in Morton versus Ruiz it was. I believe this was their policy and practice of publishing, any departure or deviation or protocol regarding eligibility requirements. I don't believe that went through a notice and rulemaking process. Now, that would be, Your Honor, the process for something like a general policy statement to suddenly become binding upon the agency. So we have a general policy statement, which under the case law supplied by the EPA is more like an informal pronouncement for the legal standard that the agency will use when applying its enforcement or adjudicatory authority. For example, in the AMREP Corp case that they cited at length in their briefing, the general policy statement in question was just an informal letter from the Federal Trade Commission to a member of Congress, one of the committee chairmen, about a general outline of the standards they would follow for deceptive trade practices. So, of course, something that would have the force of law like that couldn't be done through such an informal process. But here, so that's why a general policy statement does require that rulemaking process. Now, here we're talking about something that's not a general policy.
Let me ask you something real fast, just and it sort of, you'll work into this probably, but at the base of this is the Executive Order 13175.
Correct.
And you're not making a direct challenge on that.
Correct.
But that's the document that results in the creation of this policy.
Correct.
Okay. And the executive order expressly disavows that it's creating any rights that are judicially enforceable in anyone. You agree with that?
I do.
Okay, so my question is, can the policy, without any rulemaking, notice and comment, expand on the base document? Can it create rights that the base document expressly disavows?
I think it can, because it would not be, what the executive order functions to do is it creates a directive for agencies to create their own procedures and protocols for tribal consultation. So by disavowing any right to relief under the executive order itself, what it's doing is disavowing a citizen or whoever's an aggrieved party's right to challenge an agency's failure to establish a procedure for tribal consultation pursuant to the directive of the executive order. Once an agency has done that and established procedures that directly impact, in this case, tribal governments and their membership, then they are held to the Morton versus Ruiz standard, as well as the 10th Circuit's Bighorn Coal Company standard, which says that agencies do have to follow their own procedures and protocols or provide, at the very least, an explanation for their departure.
To follow up on that, the executive order is merely a pronouncement by the president in most cases that this is the way, my agencies, i.e. the EPA, are going to operate. Generally, if the agency doesn't follow an executive order, that's a dispute between the agency and the president.
Correct.
And because of that kind of Article 2 issue, most of the cases, as I understand them, require a statutory basis to ensure that there's a judicial review process, right? What's the statutory basis that we can hang our hat on that would allow us to give judicial review of this particular policy document?
Well, there's no statutory basis for the executive order, nor is there a statutory basis for the consultation policy. It's a normative standard that's been set by the courts for a policy, or excuse me, not a policy, but a procedure of this nature. And of course, there's also the APA would be the statutory hook in that sense, in that the precedent provides that a failure to comply or uphold procedures that impact the rights of others does render that agency action arbitrary and capricious. Your Honor, I'd like to reserve the remainder of my time for
Yeah,
rebuttal
thank
if
you. You
possible.
may.
Thank you.
Let's hear from Mr. Higgins.
Good morning.
Morning.
May it please the court. I am Elliot Higgins from the Department of Justice representing EPA. With me at council's table is Makram Shobert. He is the counsel for Respondent Intervenor Deseret Generation and Transmission Cooperative. Your Honors, I will seek to make 3 points today. First, EPA was under no enforceable duty to consult the Ute tribe here. Second, even if there were such a duty, EPA discharged it by meaningfully consulting the tribe. And third, EPA acted consistently with its trust responsibility. I will start with the lack of any enforceable duty to consult the tribe. The only two potential sources of that duty are Executive Order 13,175 and EPA's related tribal consultation policy. The executive order is not enforceable for the reasons explained in EPA's brief at pages 14 through 15. That is, the order is not based on any statute, the order itself expressly precludes judicial review, and the order supplies no law to apply. Perhaps in recognition of
We
these...
hang our hat on the APA, arbitrary capricious review or failure to follow the law as the jurisdictional hook here.
Well, as an initial matter, Your Honor, I would say that the agency did follow the policy. You know, the agency, there are 4 phases set forth in the policy: identification of the agency action, notification of the tribe, solicitation of comments, and then response to those comments. EPA followed all of those steps. So I think there is no argument that EPA, in fact, departed from the policy and therefore under the APA required to provide some explanation for the departure because there was no departure. So, but you're right, Your Honor. I mean, EPA does hang its hat on the tribal consultation policy, and like the executive order, the policy is unenforceable. The AMREP case, which my friend mentioned earlier, holds that there are only 2 methods by which an agency may formulate binding policy: through rulemaking procedures or through adjudications that create binding precedents. The EPA's tribal consultation policy was not promulgated under either of these mechanisms. In its reply, the tribe attempts to get around that straightforward conclusion by insisting that the tribal consultation policy is not in fact a policy at all, but a procedural rule enforceable under Morton v. Ruiz. As an initial matter, Your Honors, we would proffer that petitioner waived this argument by making it for the first time on reply, and in any event, the argument fails on the merits. The legal treatise Wright and Miller, sections 8,202 and 8,203, provide guidance on the distinction between policy statements and procedural rules. Generally speaking, a policy statement advises the public about how the agency intends to exercise a discretionary power prospectively in the future. A procedural rule, on the other hand, is a rule that dictates the manner in which parties present themselves or their viewpoints to the agencies. Here, considering these 2 definitions, the tribal consultation policy is just that, a policy statement.
Would you do me a favor? Sure. What were the sections on your Wright and Miller site?
Sections 8,202 and 8,203. Okay. And those sections surveyed the case law describing what is a general statement of policy as well as what is a procedural rule under the APA. As far as I know, those terms aren't defined by statute, but they've been interpreted through the years through case law. And again, a policy statement, according to Wright and Miller, advises the public about how an agency intends to prospectively exercise a discretionary authority, while a procedural rule dictates the terms by which parties present themselves or their viewpoints to the agency. So
Can the agency arbitrarily depart from its policy statements?
Well, I think you need to look at whether the policy statement is binding or not. If a statement is binding, I think certainly an agency would need to explain why it is departing from that policy,
And what's your distinction between a binding and a non-binding?
Well, a binding policy has been promulgated via notice and comment or via an adjudication that sets precedent for the agency, whereas a non-binding policy is not promulgated under either of those mechanisms.
And the agency can depart from a non-binding policy arbitrarily, on a whim, capriciously.
I think that's an open question, Your Honor. I think it would be certainly best practice if an agency departed from a non-binding policy that.
Well, if it's an open question, then maybe we do have judicial review here.
Well, in that case, Your Honor, we would take the position that there's no departure from the policy here. EPA followed it to the letter of the policy. I won't say the letter of the law because it's not binding, but followed it to the letter of the policy. The policy identifies 4 stages. You must identify actions that implicate tribal interests. You must notify the tribe about those actions, solicit the tribe's comments, and then respond to the tribe's comments. EPA did all of those things here. And, if you look at it more granularly, EPA held 4 meetings. There was a notification, a pre-consultation meeting, an information meeting, and then 2 technical consultation meetings. So while my friend earlier said that there were only 2 hours worth of consultation, I think actually if you look at it in the broader context, including the pre-consultation meeting and the informational meeting, we had many hours of opportunities for the tribe to provide input on this action.
What are the different forms that consultation may take?
Well, EPA seeks to facilitate consultation typically via in-person meetings or via Zoom or Skype. In this particular case, and I think there is some variance because again, it's a non-binding policy. But in this particular case, there were 4 meetings. A pre-consultation meeting in which the agency notifies the tribe about this impending action, an informational meeting in which it describes the imminent proposed action, and then 2 consultation meetings where the tribe actually has an opportunity to provide feedback once they've had an opportunity to review the draft, in this case, the draft Title V permit. But there were also opportunities for, the exchange of written documents. So in this case, pursuant to notice and comment, the tribe submitted written comments on the draft permit. The agency created a response to comments document. And here, even though it was under no obligation to do so, provided a draft copy of that response to comments document to the tribe so the tribe could provide further written feedback. And all of this, the end goal of all of this was to facilitate meaningful consultation between the tribe and the agency here.
I'm sorry, go ahead, Tim.
Go ahead.
What do you do with the argument that a large part of the EPA's consultation didn't occur with the right people within the tribe?
Well, Your Honor, neither the executive order nor the tribal consultation policy dictate who on the part of the the tribe must be present for those consultation meetings.
No, I get that, but I mean, at some point, if your point is that you can talk to whoever you want, at some point that could be a sham. You could go seek out somebody who didn't really care, or who had no authority, those type of things, and have consultation with them, and you would effectively be circumventing the policy behind the whole thing.
Yes, Your Honor. Well, 2 points in response to that. The executive order does require, or at least advise the agency to consult with tribal officials. Here we did that. The agency consulted with tribal officials throughout the 4 meetings. Petitioner's main complaint, as far as I understand it, is in one of the 2 explicit consultation meetings, the full tribal government was not in attendance. But neither the executive order nor the policy say that consultation may only occur if the full tribal government is in attendance. Or, likewise, the policy does not insist that EPA must consult in the manner in which the tribe would most prefer. Now, to be sure, the agency does endeavor to consult in accordance with the tribe's preference, but I think the more salient point is it's under no obligation to do so. And certainly here on these facts, it was no sham. EPA sought to consult with the right people. And on at least one occasion, the petitioner concedes that EPA did consult with the full tribal government, which is their preference. Finally, Your Honors, I'd like to move to my third point, which is that EPA acted consistently with its federal trust relationship. To prevail on a breach of trust claim, a tribe must establish that the text of a treaty, statute, or regulation impose certain duties on the United States. Here, the tribe fails to identify any statutory, regulatory, or treaty-based duty requiring EPA to act in a trustee capacity with respect to issuing Title V permits.
Counsel, can I stop you there? So let me just ask you, are you taking the position that you could make all decisions with regard to this plant without speaking to the tribe? I know you say you wouldn't do that, but does your position suggest that you have no obligation, either under the trust responsibility or any other source, to speak to the tribe at all?
Well, Your Honor, I think we have two distinct issues here. So one is the conventional fiduciary duty, trust-creating duty, under which a tribe may bring a breach of trust claim. That is not this case, because the
Right, but I mean, you're saying you don't have an obligation under the trust responsibility.
Well, Your Honor,
They could try to bring a claim, but it would lose, correct?
that is correct, Your Honor. Although I would say that the agency does feel strongly about adhering to its more general trust responsibility to tribes. So, it's our position that we discharge that responsibility by complying with the Clean Air Act, by considering the tribe's interests to the extent we have discretion to do so. So I would be reluctant to say the EPA has absolutely no obligation whatsoever.
Well, tell me what the obligation would be. I understand you don't want to say that, and that's why I'm pushing you on it. But I'm trying to figure out, is there any obligation under anything to speak to the tribe before you make decisions with regard to the plant?
Your Honor, yes, under the general trust responsibility, EPA respects that relationship, and EPA does endeavor to consult with the tribe to the
I
extent.
know, but that's not what I ask. I'm sorry. But I just have to push you. There's no legal obligation. You want to do what's right. That's what you're telling me. You endeavor to do what's right, but there's no legal obligation to speak to the tribe at all under your position. Just tell me, is there anywhere?
I would be reluctant to go that far, Your Honor, but I think the more salient point from our perspective is that a tribe could not bring a claim solely under the general trust obligation. That general trust obligation exists. EPA endeavors to treat the tribes with respect as sovereigns, but the tribe cannot, under recent Supreme Court case law, the Jicarilla case, the Navajo Nation case, EPA cannot bring a standalone claim under that general trust obligation.
Well, yeah, and just to follow up on that, assume that the executive order was rescinded, so there's no policy document here. I wondered why you were reluctant to say you had no duty if it's non-binding, but let's say it's repealed. Does the general trust obligation provide, would that be the only avenue for the tribe to claim a right to some type of consultation?
Yes, Your Honor, I think that would be the only basis for such a claim, although again, our
You say
position.
there's no basis for a claim here because there was consultation or because something
Because
else?
because the general trust obligation does not provide jurisdiction to the courts or otherwise enable tribes to bring standalone claims under that. They have to identify a treaty that's been violated, a treaty that imposes a duty on the United States, a statute, a regulation that imposes a
Like
duty.
the Clean Air Act claim would be.
Right. So here, our position is the Clean Air Act imposes no such duty.
Right.
Had it imposed such a duty, they could bring such a claim, but it does not. So in conclusion, Your Honors, if there are no further questions, I'll see the rest of my time and sum up by saying the petition for.
And just before you sit down, if we were talking about a state instead of a tribe, would all of your answers be the same? say, the state of Utah?
If the state took the position that we had not consulted with the state,
Right.
Your Honor, we didn't brief that question, and well, certainly all of the trust case law that we have been discussing would not be relevant. It may be the case that under the Constitution, the 10th Amendment or something to that effect, there would be, but I'm reluctant to speculate, having not actually researched that question.
All right, thank you.
I see that my time's up. Thank you very much.
Have some rebuttal time?
Thank you very much, Your Honor. I would like to use my limited rebuttal time to discuss the trust responsibility and the EPA's trust relationship with the Ute Indian tribe. Now, what the EPA is trying to push here is essentially what we call the Mitchell II standard, which is the standard for establishing a specific enforceable fiduciary duty, normally in money damages, that you can enforce for failing to uphold that specific duty. For, in the Mitchell II standard, that was the management of tribal timber for the economic benefit of the tribe. I want to make a very important clarification that the trust relationship does not begin and end with the Mitchell II standard for specific enforceable trust duties. The trust relationship exists notwithstanding that, and that's important here for two distinct reasons. One, as EPA indicated, there is a tie between the general trust responsibility and the agency's obligation to engage in some level of consultation with the tribal government. Now, part of that trust relationship is upholding tribal sovereignty, and the very constitution and bylaws of the Ute Indian tribe provide that the tribal business committee is the governing body of the tribe that interfaces with federal agencies. So the EPA is inconsistent with this trust relationship for the EPA to pick and choose who it consults with, whether that's low-level tribal officials or the business committee. Second, I want to clarify that even the standard for the relevant factors test, which is all parties have agreed that an agency action is arbitrary and capricious if not all relevant factors were considered. Under Cheyenne-Arapaho and under Woods Petroleum, the trust relationship and the consideration of the best interest of the tribe is inseverable from this relevant factors analysis, regardless of whether we've identified a specific fiduciary duty by statute under the Mitchell II standard. Thank you.
Thank you, counsel. Appreciate the arguments. Those are helpful. The case is submitted and you're excused. Big crowd for that case. I think it's like the environmental law or Indian law. It's, class B or C.
I was just thinking about what you were just saying about environmental law. Maybe it can be done at a higher policy level.
Give me the thumbs up when you're both ready. Okay. Our next case is 24-4057 RC Smithfield versus United States. Mr. Black for the appellant.
Good morning, Your Honors. May it please the court, my name is Mike Black, and I represent the appellant R.C. Smithfield in this case. The most important aspect of this case, in my view, is defending the distinction between what a member of a business entity or a shareholder of a business entity owns, which is their membership interest or their shares if it's a corporation, and what the business itself owns, which is its operating property and the things that belong to it. That distinction is key in the law for how business entities function as distinct legal entities. And it's that distinction that the IRS action and the court's decision below have blurred in this case, and that requires correction by this court.
Did you make the argument, I assume what you're saying is if the IRS wanted to attach something or put a lien on something, it was not the physical property itself? That they should have been able to do that?
What they were entitled to do, Your Honor, in this case, they have made out a perfectly valid claim against Mr. Crookston's membership interest. And had they pursued that and tried to collect that membership interest, that would have been fine. I would have had no complaint, especially as the company's lawyer, I would have no complaint at all because he is not my client. But that's not what they did. What they did is they said, by virtue of his membership interest, we can reach through the LLC and lien the LLC's property directly. And that's where they went through this wall that exists between what the entity owns and what the member owns.
I mean, at some point in these kind of cases, the corporate form can be pierced. You can reach through it as either being a sham or something like that.
Certainly. There are lots of arguments that can be made to invalidate an entity, to call it a sham, to disregard it, to say that it was, that there was a fraudulent transfer in this case, would also invalidate the particular transfer. To call it an alter ego would be another option, none of which were done by the government in this case. Instead, what they chose is they chose to assert a nominee lien, which did not require them to take any other action other than file the lien. And that's why they did so, because it's a very convenient way to attach property and to keep it from being sold. So they had lots of other options. They just chose the one they couldn't take. And so if I can walk through this here, the LLC.
Yeah, as you do that,
Certainly.
as I understand the district court's order, it concluded that the Sid Crookston Construction did not gift its interest to the LLC. It kept a residual interest, and that's the property right that the IRS is going after. And is it a fact question whether or not it was a gift? And did the district court determine that it was not a gift? Therefore, there's a resulting trust with, an equitable interest that can be identified and attacked.
Your Honor, the ruling by the court is perhaps a little confusing in this respect, but what I did in my papers is try to chart out and put together a little bit of a flow chart of those funds. Whether or not Sid Crookston Construction, the company, made a gift or not to Alden Crookston, which is how the money flowed, is again not my issue. If it was not a gift, that's fine. They've made a claim against Alden. I don't dispute any of those factual findings. Those are perfectly valid for purposes of this here today. The issue is not whether Sid Crookston Construction gave money to Alden and intended it to be a gift or intended it not to be a gift to Alden Crookston. The question is whether or not the IRS's lien rights and ability to attach the property stopped at Alden, or whether they could then continue to reach through the LLC, which is what they've done. The court did not rule that the LLC was a sham, that it was to be disregarded, or that it had or that it was an alter ego in any way, shape, or form. In fact, the court's ultimate ruling was that the lien was limited to Alden Crookston's interest in R.C. Smithfield, which presupposes that R.C. Smithfield is an existing entity and that he has that lien, and that he has that membership interest. That is distinct from the other member who, for all purposes that are relevant here, is pure as the driven snow. The IRS admits it has no lien rights against his membership interest or to the company with respect to his membership interest, which makes it so crystal clear that this is reaching through the entity on behalf of Alden and his membership interest, which is what is not permitted by statute.
So it seems like the district court thought that the LLC, while holding legal title, did not own the equitable title to half of that property, that half the equitable title belonged to Mr. Crookston, right?
I'm not sure that it's half of the equitable title, Your Honor, because that's not what the court ultimately held, and that's not what the lien said. The lien is with respect to Alden's membership interest, which, as to that property, is nothing, because as I've cited, the member has no claim to the property of an LLC in the state of Utah.
Yeah, I mean, fair enough in a perfect world, but there are other facts here other than if all the corporate form had been followed perfectly, all the financial transactions had been in the name of the LLC, all the money had gone directly from Alden to, or, there were other documentation making it all really clean, fair enough. But there are also facts in this case that suggest that Mr. Crookston was not intending to give up his interest in the property in the way this transaction was structured, that he kept using it, he was dumping things out there, there was the lock with his combination on it, all these good things. There were things that indicated that he intended to continue to personally exercise control over it. So, I mean, that changes it a little bit, doesn't it?
If I understand, let me see if I can rephrase this, Your Honor, because an LLC can certainly be a nominee for a third party, right? It's a legal entity just like everybody else, and to the extent that anybody else could have that relationship, so can an LLC. But it has to be between the LLC and that third party in that context. What it can't be is between the LLC and its member in their membership context. And so
He wasn't a member.
And he was not. And so had the court said that the LLC is in its relation directly with Sid Crookston Construction, has that relationship of being a nominee, that would be a different thing than what actually happened, which was that the lien is only as to Alden's membership interest. It is specifically in that context. And that is the error. It has to be outside of that context for any of these theories to have any room, because the statute details how members and these companies relate to each other vis-a-vis that membership interest. And there's no room for these other theories to intrude on that.
You will probably want to joust with me on this, but it seems like sometimes in these proceedings, there's things that are said loosely, like the lien only goes as to Alden's membership interest. Is it a fair reading of the record that when the district court made that pronouncement, that it was more aimed at the amount of interest in the property that would be covered by Alden's interest? Does that make sense? So Alden owns 50%, ergo IRS can attach 50% because Alden really didn't own any of that property. That part of the property was equitably owned by Sid.
If that statement had been a one-off, Your Honor, I might agree with you. Okay. But that statement was exactly how the IRS phrased it in their lien. is that it was to the extent of his membership interest in R.C. Smithfield. That's what was admitted in their answer. It's what was admitted in their discovery responses. It's the exact language that was used at the trial, and it's the exact language that shows up everywhere in that ruling. And so this is actually, honestly, one of the problems with this lien, is that there is no way to resolve it because it doesn't have a number. Instead, what it has is it's keyed to something else that is in dispute. So it's not that if the IRS had been tracing funds, right, they could have said the lien is for the $50,000 that was paid into escrow. That would have been helpful because then you know how you resolve the lien, right? You pay the $50,000 and the lien goes away. Instead, what we have here is a lien that's keyed to a membership interest that may or may not have any value because, in fact, he has no claim to that underlying property. It may have less value based upon the interactions between the partners. If the other partner had paid more, what would his membership interest be? Would it be 50%? Maybe it's only 40%. There's absolutely no way for R.C. Smithfield to resolve this lien at all. There's nothing that can be done because of the way that it was phrased and because it intrudes on that relationship between the member and the membership interest and the company. If I may, I'll reserve the remaining time for
You may,
rebuttal.
thank you. Let's hear from the United States. Ms. Wicks.
Good morning. May it please the court. I'm Marie Wicks on behalf of the United States. I'd like to begin by emphasizing the substance and the realities of the facts here. Sid Crookston Construction paid for the parcels and received nothing in return. R.C. Smithfield paid nothing and received title to the parcels. And Alden Crookston paid nothing and received a membership interest in R.C. Smithfield. Under those circumstances, Utah, like any other state, recognizes that the person who pays for the property has an interest in it.
So that's, I mean, part of that is not uncommon, is it? People paying for, I mean, let's take Alden out of the mix. And let's say that the membership interest, that the construction company paid for half the membership or half the property and got a membership interest. That wouldn't be unusual. There's nothing untoward about that, right?
Right. What's unusual is the continued beneficial ownership of Sid Crookston Construction.
And so tell me about that. I mean, what's the indicia of his beneficial ownership? Because the properties, I mean, wouldn't we start with like maybe a presumption that the title holder owns the property?
Legally, that is a presumption.
Okay, and so then it's your job to come in and sort of show facts indicating that while that may be what the record shows down at the county courthouse, somebody else has an interest that nobody knows about.
Right, exactly.
Okay. And in this case, your position is it's Mr. Crookston that he caused his construction company to make these payments, basically tried to hide it by putting the membership interest in his son's name, but he kept using it as it was his own.
Right, so the taxpayer is Sid Crookston Construction and its successor in interest, ACI, and Sid, Mr. Crookston is the owner, or was the owner and manager of Sid Crookston Construction. And That's right. So the district court found 3 different bases for defining an interest in the property that belongs to Sig Crookston Construction beneficially. Any one of those is sufficient for the federal tax liens to attach under the dry craft Supreme Court analysis. And also, the fact that the tax liens do attach to a state law property interest is not being challenged on appeal. So once the state law interest is defined, the federal tax liens attach under Section 6321, property and all rights to property. So it's typically a 2-part test. The ultimate question is one of federal law, and that's not being challenged here.
Okay, let me ask you this. So the best you can do, you can attach the construction company's SCC and ACI's interest in the property, right? That's what you get.
Right.
Which is not a record title interest, it's a beneficial interest of some sort.
Right, in the property itself.
Okay, and so if you, for example, wanted to, force a sale, if you were the defendant in a quiet title suit, you would then have to prove up their interest, their beneficial interest in trial.
Right, and here the district court found sufficient evidence under the clear and convincing standards for constructive and resulting trusts and preponderance of the evidence for the nominee theory. And none of the findings of fact are being contested on appeal as well. And so...
Let me ask you about the nominee theory. So the district court has, as I understand it, in another case, disavowed her decision based on the nominee theory and said that she got it wrong. Are you still pursuing affirmance on the nominee theory in this case?
Absolutely. We
Okay.
believe the district court got it right in this case in deciding that the Utah does recognize the principle of nominee. And as our brief mentioned, other courts have looked to fraudulent conveyance, the factors considered in fraudulent conveyance cases to determine whether nominee is recognized in the state. So Scoville in the 8th Circuit, Dalton discussed that in the 1st Circuit. And another case we mentioned, Fourth Investment out of the 9th Circuit, is an excellent example. They looked at California cases regarding nominee. And so that the framework of considering how the highest state court would decide an issue is excellently presented in the Fourth Investment case as well. Right, here we cited 3 different cases, which I'll note were not before the district court in the estate of Crookston case, where the court said that Utah does not recognize nominee. The court did not have before it these cases we cited in our brief, Butler, Gavon, Donkin. And so it all stems from early understandings of the ancient law of equitable ownership, and going back to Twine's case out of England. So looking to those cases, other cases in Utah, Free v. Farnworth, and another case, Capital Assets Financial Services versus Maxwell. It's a 2000 Supreme Court of Utah case. Utah recognizes beneficial ownership in property.
Well,
And-
counsel, can I just stop you there? Does your case, though, depend on the nominee theory? I guess I'm curious, you're defending it here, but does your case depend on its existence, or do you prevail under either of the other 2?
We prevail on any of the 3, including nominee. So no, it doesn't, we are not hanging our hat solely on the nominee theory.
Okay.
constructive trust and resulting trust were
Okay,
also.
of those two, which one do you think is the strongest? Resulting trust or constructive trust?
They're both equally strong in my view. The resulting trust, a good example out of the 10th Circuit is the Tingy case. And here, the elements of resulting trust are met, as the district court found. The court found on Appendix 67, U.S. has proven by clear and convincing evidence that Sid Crookston Construction did not intend that R.C. Smithfield have a beneficial interest in the property. So that's one of the considerations under a resulting trust analysis. And here, the transfer of the property was made to one person, purchase price paid by another, and the trust arises in favor of the one who paid the purchase price. And likewise, under the constructive trust theory, it's an inherently broad scope under Utah law. In the Rawlings versus Rawlings case, the forms and varieties of constructive trusts are practically without limit. So here the district court found that there was unjust enrichment. Sid Crookston Construction was unjustly enriched by allowing it and its successor to exercise control over the parcels through the contributions of funds that belong to the United States and Sid Crookston's Construction's other creditors. And that the wrongful behavior can be directly traced to the parcels because Sid Crookston Construction and ACI funneled the money that should have been used to satisfy the federal tax liabilities into purchasing these pieces of land.
You sat there and listened to Mr. Black's presentation. What would you say the principal flaw in it is from your perspective?
The principal,
Flaw.
flaw.
I'll let, he's going to stand up and defend himself.
Right, so I would say 3 different points responding to my friend on the other side. First, as Judge Timkovich, you mentioned in your questioning, Sid Crookston Construction did hold on to a residual interest in the property despite paying for the transfer of title to R.C. Smithfield. And the district court did find on appendix page 50 that it was not a gift. And also the distinctions collapse between the membership interests and the property itself here, where the facts, the realities, the substance shows that Sid Crookston Construction was the beneficial owner of the property. Sid Crookston continued to participate in meetings related to the property. He controlled the combination lock, and they continued following the transaction. SCC's successor in interest continued to use the property to deposit its construction materials without the permission of Mr. Richens, in fact. So the reality here is that any by-the-book legal distinctions have collapsed here. Also, the language of the Notice of Federal Tax Lien itself does not bind the government. The filing of the Notice of Federal Tax Lien is just that, it's a notice, so it does not represent the actual lien. When a taxpayer fails to pay after notice and demand, a lien arises in favor of the government. So it arises automatically. The Supreme Court in the Snyder case back in 1893, I believe, said that it does not need to be recorded to be valid. Also here, in the ACI construction case, the district court did find that the liens were valid against SEC and ACI. So the lien here is valid. the language of the notice does not change the reality that Sid Crookston Construction has a beneficial ownership to the extent of Alden's membership interest in RC Smithfield. And that language there shows that Mr. Richens did purchase half of the property, so we're only going against the half that, approximate half that Alden Crookston has by virtue of Sid Crookston.
Do you claim an
Constructions.
interest in Alden's membership interest?
Yes, but here the property itself is really the object of the federal tax liens.
No, I
in
understand.
this case. Let's see. Yes, so because there were no other challenges to the fact that the tax liens do attach under dry and craft, the district court found 3 different very solid reasons for holding that there is a property interest of SEC in the parcels at issue. This court only needs to decide one in order to support and affirm the district court's holding here. And if the court has no other questions, we
I
rest
do.
on our brief.
Was there any evidence in the proceeding below that SCC, ACI, or Mr. Crookston ever disavowed an interest in the property? Was there testimony, anything like that?
The Crookstons did testify in general. I do know that the district court's findings as to the credibility of the Crookstons' testimony was that it was self-serving and not credible. So I don't recall specifically any disavowance, but I would note that the district court did find that their testimony was not credible.
Okay, thank you.
Thank you, Counselor. Your time's expired. Mr. Black, you have some rebuttal time. Now you can tell me what the flaw in her identifying the flaw in your argument.
The meta flaw. And I'm not quite sure what flaw there was that I would want to point out here. But what I do want to point out is this, is state law determines property rights. Federal law only determines how they're taxed. And Utah state law does not permit alternative ways to get what is prohibited by statute. And by statute, an LLC is distinct from its members, and its members have no claim to the LLC's assets. Those are distinct. And that is enshrined in both the case law that I cited as well as in the statutes. So a creditor, the IRS, cannot look through an LLC without something else. I mean, there are obviously ways to pierce the veil, but without going through that particular type of claim, there is no way for the IRS to pierce. There's no way for another creditor to pierce through and say, oh no, I actually do have that claim. There's also no way for the member to do so, which is what I care about deeply in this case because I represent the LLC. I care about maintaining this distinction between the property of the LLC and the property of the member, both for the IRS and for any other claimant who might try to assert that they have a way to do this. They cannot, that distinction is clear. There's a wall there, and you cannot, any of those people cannot say, oh no, I don't like that wall, and so I'm going to assert that they are a nominee for me instead, and then I do have a claim against those assets. They cannot say, I'm going to instead assert that there is a constructive trust inside this LLC, that it's not really an LLC where I have to obey the statute. Instead, I'm going to try to call it a constructive trust or a resulting trust. None of those alternative theories are available in Utah to bypass what the statute makes very clear, and that is that a member does not have a claim to the assets of the company. And that cuts off this claim to lien R.C. Smithfield's real property directly through the membership interest of Alden Crookston.
Now, all of that just takes us back to what you and I were talking about originally, and that is that where all the formalities are perfect and everybody's followed these things carefully, that can be so. But in situations where there's an indication that the LLC, through its management or through its members, agreed that someone was going to retain beneficial title, then you would not have to go through that membership interest, would you? You would be able to pursue that interest directly as a beneficial owner.
Yes, if you had a different avenue to do so, most certainly that would be an available method to make that claim against an LLC. But here we have, it's clearly through the membership interest. There's beyond any doubt that that is the mechanism that they are getting at the property.
Okay.
Thank you.
Thank you, counsel. We appreciate your arguments, your excuse, and the case is submitted.
Good morning, Your Honors.
All right, let me call the case, and then you can introduce yourself. This is 25-4041, Carlson versus Carrington Square.
Yes, sir. Good morning, Your Honors. My name is Amanda Reynolds. I have the honor of representing Danny Carlson in this case, pro bono. He is an individual who is humbled by multiple sclerosis. He, on May 7th, 2021, fell in his bathroom as a result of the absence of grab bars in his bathroom. He was later evicted constructively from his apartment on July 30th under the guise of a construction remodeling project. The district court dismissed our case outright, carte blanche. We argued that they were erroneous in nearly every single holding against us, and their failure to render holdings on certain cases, including the expert testimony, preclusion motions, and the motions to compel. As a matter of housekeeping, the district court held in favor of the defendants, respondents in this case, with respect to local rules that allegedly weren't followed or were violated by the plaintiff, including in the motions to compel, claiming that we didn't comply with the word count certification or the word count whatsoever.
If I could, you make some extraordinary claims in your brief, and in particular, are you alleging that the district court was biased in its ruling against your client? And if so, I was wondering what parts, what evidence was produced or what part of the record would demonstrate that and back up that assertion.
Sure, and yes, we're arguing that the district court was biased. We were confronted, when I brought this case, I was not aware that the Cullimore defendants were politically affiliated in Utah. And I also didn't know that I wouldn't be able to refer to any other attorneys in Utah because there simply are none who would take this case.
Why is that relevant?
It's relevant because these Cullimore defendants also represent 80% of the landlord defendants. Their
And why
lease,
is that relevant?
because their lease in Utah is unconscionable, yet it's accepted by Utah courts everywhere. It should not be enforced, and it is. Nobody understands why it's enforced. There should be a class action to render it inherently unconscionable.
Well, you've sued lawyers in a law firm here.
Yes.
What's the factual basis for that claim?
We sue them under a third-party beneficiary theory because in Conlin v. Cullimore defendants, they've been sued before for this reason, and the court found that they had a duty to these plaintiffs who were tenants under the third-party beneficiary theory because they are in a unique position as the so-called kings of eviction, debt collectors in Utah, for drafting and advising Utah landlord tenants as to how to essentially amass fees and collect fees that are not necessarily warranted, and then to evict their unwanted tenants.
Is there a Utah case that supports that third-party beneficiary?
Yes, in the case Conlin versus Cullimore defendants in which they were sued, the court ultimately dismissed the motion for summary judgment, but found that there was a duty and there was causation against these defendants, so they were on notice that they were and had a duty under a third-party beneficiary theory. This is not news to these defendants, which is why.
Can I stop you for a minute? I'm interested in the case you just mentioned, and I didn't quite get the name. The case that
Conlin v. Cullimore.
Conlin
Yes, sir.
v.
Cullimore, the defendants, respondents here, Cullimore.
Okay, and that's a Utah state case?
Yes, sir.
Okay, thank you.
Thank you. So really, I would rather just be of service to the court and answer any questions that you might have, but there are some points of clarification that I do have with respect to the brief that I just want to point out expediently, if I may. Under McDonnell Douglas, the burden shifting framework, defendants allegedly, defendants proffered a pretext. The district court found that it wasn't pretext. We're saying that it is. The district court then went beyond the province of the court, and instead of remanding it or permitting it to proceed to trial through a jury, made its own assessment as to whether or not it was pretext.
So right here, are you talking about your fair housing claim or your ADA claim?
Both of them.
Both of them, okay.
So we have essentially defendants who said to my client, we don't have an apartment for you to rent because we know you're handicapped, but we gave it to someone else 4 days later, right before we evicted you, without giving you sufficient notice, because there's no such thing as sufficient notice when you're evicting someone on the basis of discrimination. And then the district court refused to grant our motion to compel on the basis of some Utah local rule, which they then used in favor of the defendants, and claimed that we had no evidence in support. But we have hundreds of thousands of pages of evidence. We also had affidavits, declarations of my client, and his testimony is evidence. So why I think the district court, if they're not biased, might be a little confused is because we supported everything. And perhaps in reviewing—
Your brief in this court seemed to not give us, it was kind of hard to find in the record because you didn't give citations to where we would find these. And it made it really difficult for us to follow your argument.
I'm sorry, I'm sorry for any difficulty I caused you in not being able to follow my argument, but I think where I rested was mostly on my papers. I don't think I could have argued any more arguments, and that's why it's also baffling, than I did in my motions to summary judgment and my oppositions in the over 200 pages of argument, and none of those arguments were accepted by the court. It's insane. And even if the arguments weren't accepted, certainly there had to be an issue of fact somewhere, which we don't think there is an issue of fact. We think that everything should have been ruled in our favor, but at the very least, you could have said that there is an issue in fact because we say there's discrimination, and they say that there's not.
Yeah, but our rules require you in your opening brief here to cite to specific points in the record that support your allegation that there's a fact question. And you didn't do that here, did you?
To support the allegations that...
Of pretext.
Yes, I do believe that I cited to the specifics in the record. Oh, I understand what you're saying now. Not in the record. I cited to the specific docket. That is correct. So I cited to the docket, not necessarily to the record, if that's what Your Honor is referencing. And I think that's what the district court may have misunderstood as the absence of evidence in the lower court briefs, where it was my failure to cite two specific pieces of evidence in the argument, but I cited to those pieces of evidence in the statement of facts and in every other area of the brief. So there's not a lack of evidence, there may have been a lack of citation.
Can I ask you a question about your ADA claim? There's been, the other side has asserted that the ADA doesn't apply to apartments?
Yes.
Because they're not public accommodations. Do we have a case on that?
Yes, so the, it starts with a P. So the public accommodations case was the one, you know what, it escapes me offhand the name of the case, but I can tell you also that the 2023 DOJ regulations, which were rendered after those cases which the district court relied upon, rendering them obsolete, indicate and clarify that those cases don't even matter because the DOJ is saying that ADA does apply to these apartment complexes, which are not private, by the way. They're private at the time that the lease is entered into, but at the time that they're held out to the public for rental, they're not private. I mean, they're essentially leasing them to the public. And there's a duty to the public to provide, as they are in the common areas, as they are in this courthouse, for the most part.
Okay, so that, you just brought up something I was going to ask you about. So I've seen some ADA cases where they said that the apartment itself is not a public accommodation, but that the common areas, the pool, the clubhouse, all those things are public accommodations. Can you address those, you know, why those cases that make that distinction would be incorrect? Have you seen those cases that make a distinction?
Yes, I think, and that's where I was getting to with the discussion of prepossessory interest rights in the property, is because there's a difference as to whether they're private or public with respect to who you're framing that in relation to. If it's a tenant who already lives in the apartment or versus people who are entering the apartment. And in this case, like in public places where, let's say there's a parking lot, there are a certain number of spaces that are required to be held out for handicapped individuals. That's the same thing with an apartment complex if you're looking at it from the point of construction, which these were undergoing construction, which are supposed to be held out for certain handicapped people. So it's different to say that something is completely private, and that's exactly where we go to the definition, because in the private definition, they're talking about places that are exempt because they're under 4 or 3 apartments. In this case, we have an apartment complex with hundreds of apartments held out to the public first. We also know that they were being remodeled since after 1998, they hadn't been, and they're required to have certain amenities, including, well, actually, forgive me, it's not an amenity to my client. We call them amenities, but they're not amenities. They're required to have them. So when you say that Danny Carlson wasn't disparately impacted by discrimination, by defendants who intentionally gave away an apartment to a non-disabled tenant 4 days before they evicted him at the threat of not having Section 8 benefits or a place to live, having to go into a hotel, pay with his own money, which he already has none of because he's on federal welfare. The defendants made it sound like he was on vacation, and that's why it's so sad. But I'd like to reserve the rest of my time for rebuttal if that's amenable with the court.
Okay, you may.
Thank you.
So you splitting arguments today? Yes, sir. All right, Mr. Barlow first.
Yes, thank you. I told Mr. Todd that I would give him exactly half the time. So he didn't want it. Your Honors, thank you so much for taking this time to hear these oral arguments on this important case. My name is Pete Barlow, and I'm with the law firm of Strong and Haney in Salt Lake City, Utah. Here we have a case that involves some federal statutes and state statutes that are designed to be shields and protections for certain people who are disadvantaged. Here, we learn what happens when these statutes are not used as shields, but rather are attempted to be used as swords or clubs to gain better or additional benefits that nobody else has. And that's the argument that the plaintiff, Mr. Carlson, made consistently throughout the lower court proceedings and which continue here today. So I'd like to use an example that's near and dear to my heart. I'm a terrible golfer, and golf has a handicap system where with my handicap, I can play against Scotty Scheffler and lose, but not lose as bad because of my handicap. And that handicap system allows me to compete on an even playing field, which is a great system. It doesn't allow me to hit a ball into the water and force my playing partner to go into the lake and get my ball for me. It doesn't allow me to force the golf course to give me a free golf cart because I don't want to walk. It doesn't allow additional benefits that aren't within the rules of the game. And consistently throughout these arguments, this is essentially what Mr. Carlson has argued, that he deserves to be treated better, not equally, better. So let me start at the ADA. The ADA simply doesn't apply to private residences or private apartments. I appreciated Judge Carson's questions about the public areas or common areas because the ADA could be applicable to those areas, and cases find that way. Here, what we're dealing with is an individual apartment residence that Mr. Carlson lived in for about 6.5 years, and whether he should be able to continue to reside in that residence based on his own demand, again, being treated better.
Is there a circuit court case that you're aware of that holds that the ADA is applicable to apartment complexes or to the apartment itself?
The circuit court cases that I'm aware of, including that Phipps versus American Property Management, that's a case by D. Benson, Judge Benson in Utah, which held that it wasn't applicable.
Okay, that would be a district court case.
There are
I mean, I'm talking about Court of Appeals.
Court of
In any
Appeals.
circuit.
Let's see, yeah, there is the Third Circuit, the Regents of Mercenburg College versus Republic Franklin Insurance Company case held that it is not, the ADA is not applicable to private residences. And frankly, Your Honor, I don't know if it addressed the issue of whether the ADA could be or would be applicable in that case under those facts to a common area. I assume that it would be, actually, but not to private residences and rights to have the ADA apply to residences that only a private individual rents from a private company.
Okay.
So the distinction is basically based on the definition of public accommodation found in the ADA. And the definitions use terms like hotel, motel, place of lodging, so short-term residences. Here we have the 6.5-year lease by Mr. Carlson, obviously long-term. And Judge Shelby was unwilling in the face of no persuasive authority against, well, that he recognized, I'll put it that way and I'll explain what I mean, that the ADA should apply to that particular private residence, which is what the dispute is over. Mr. Carlson claimed that there were DOJ-like regulations or something that were applicable that I think I just heard today that essentially overruled or superseded the court cases. The way I understand it is the DOJ is the arm of the executive branch, and I hold the judicial branch very dear to my heart. And so the thought of the DOJ being able to overrule any court to me seems unfounded. So, but Mr. Carlson failed to cite to evidence in the record that would be able to show that these cases that we've cited in our brief should be disregarded or a different result should have been reached below in the summary judgment motion. Any questions on the ADA? I was going to move on to the Fair Housing Act. Okay, thank you. So with regard to the Fair Housing Act, we agree that the Fair Housing Act applies to places like Carrington Square Apartments. And what the plaintiff has alleged is that there was both disparate treatment, so an intentional discrimination that doesn't have to be proven through circumstantial evidence or presumptions or anything like that, or a disparate impact, which is basically based on the circumstantial evidence, because it is hard to prove discrimination. You don't know what's going on in my mind. I'm afraid, by the way. But, you know, you don't have to prove that with the disparate impact arm of this claim. So the district court below, I believe that Judge Shelby, and he expressed this in his opinion, had the same types of concerns that you expressed with Mr. Carlson, that there wasn't proper citation to the record or that there were citations to claimed evidence that Judge Shelby did not find to be competent evidence. And in terms of determining what evidence is admissible, what evidence is not admissible, those determinations are reviewed under an abuse of discretion standard, which I really haven't seen any argument from Mr. Carlson about. There are many claims that Judge Shelby was biased or prejudiced or whatever the claims are. But the proper standard of review and the reason why the evidentiary decisions were made or not made the way that they were made were not really addressed in in the brief. And so to the extent that those arguments weren't briefed, they're waived. With regard to the disparate treatment arm, that goes under the McDonnell-Douglas burden shifting analysis, which requires a plaintiff to set forth his prima facie claim of discrimination, and then the burden shifts to Carrington to submit a legitimate non-pretextual reason for the action. So here, Carrington was involved in a apartment-wide complete renovation of the properties. Carrington was built in 1998, no renovations until about 2021. People were complaining about the outdated styles. I don't get it, but my wife would. And so in order to bring it up to the community standards and protect the investments, they decided to invest millions in this project. And there were declarations, affidavits to that effect, which were not rebutted. In fact, Mr. Carlson seemed to acknowledge that this was a process that was happening. And so Judge Shelby found that that was a legitimate non-pretextual reason. So the burden shifted back to Mr. Carlson to show that the legitimate reasons were pretextual. Now, follow me here. A company spends millions of dollars on a renovation project just to get rid of one disabled tenant that they had been accepting rent from for the last 6.5 years. That's a terrible way to go about that business. And so Judge Shelby rejected that claim of being pretextual. I'm out of time. I need to reserve the rest for my co-counsel.
All right.
Thank you, Your Honors.
Thank you.
Good morning, Your Honors. May it please the court. My name is David Todd. I am here representing the law offices of Kirk A. Collimore, LLC, Kirk A. Collimore, and representing myself, David R. Todd. I'll refer to us as the Collimore defendants, and just would like to point out that the court's ruling, the difficulty with this has been for many years going through this litigation is really trying to pin down exactly what the claims have been against the Collimore defendants and how they're interspersed throughout the pleadings. But I will just address essentially where Judge Shelby got this right, and that is that the Collimore defendants, there was no factual dispute at all that any of the Collimore defendants were housing providers or governed by the Fair Housing Act related to these circumstances. The motions that were filed with the district court provided facts that just were undisputed. And that's been the issue with this case from the beginning, is there's just a lack of facts that would support Mr. Carlson's claims against the Collimore defendants. So the undisputed facts show the Fair Housing Act just does not apply in this situation to the Collimore defendants. Also, the breach of contract claim, and the third, it initially was, and I can't recall if it was included in the district court case, but it was a theory of third-party beneficiary and fourth-party beneficiary. Essentially, Carlson claiming that what it had always been claimed to us was that he was claiming that he was somehow a third-party or fourth-party beneficiary of the legal services contract between the Collimore defendants and the Carrington defendants.
So your opposing counsel says that in another case with apparently Kaylee Conlon as the plaintiff, that a court said that Ms. Conlon was a third-party beneficiary to some contract of yours. Is that true?
I don't believe that that's true, and I will admit I haven't read that case in a little bit, but that case would not have had a holding that the client agreement between attorneys and the other party somehow brings in a third-party beneficiary claim. And that's been one of the difficulties with this case is that that's continued to be a claim, is this third-party beneficiary claim. And we haven't really been able to nail down, is that a claim third-party beneficiary related to the lease agreement between our clients, the Carrington defendants, and Mr. Carlson? Or is it a claim of third-party beneficiary from the client agreement to provide legal services? And so the Collimore defendants have continued to request some kind of precedent to show that that exists, that there's something out there about a third-party beneficiary where somebody who's an opposing party can come and say, no, I'm a beneficiary to your legal services contract with your client. And really the only well, maybe not the only, but at least one case that was found that we did include in our motion that Judge Shelby heard and granted was a case in Utah, it's Sunridge Development Corporation versus RB&G Engineering, and that kind of outlines what is needed for a third-party beneficiary claim. And one of the things is that the contract itself has to specifically indicate that there's an intent for that other party to be a beneficiary. And that just does not exist here. What was argued at the motion for summary judgment stage, again, was related to the client agreement between the Collimore defendants and the Carrington defendants. The contract was provided. It was not disputed. That contract, the only written one that existed that was provided was, I believe it was a 2012 contract. That was well before Mr. Carlson was even a tenant at the property. And it would be very unusual to see that Mr. Carlson would have been included in a client services contract like that. So again, it was a little bit difficult to determine which of the claims were all related to the Collimore defendants, but the fair housing and ADA, again, the facts were never disputed. At no time has Mr. Carlson made a claim that there are some facts that show that the Collimore defendants were involved in providing housing, denying reasonable accommodation requests, or engaging in any type of negotiation to rent any property. I'm going to stop there unless the court has any questions.
Hearing none, you may be excused. Thank you.
Thank you.
And we had some rebuttal time left.
Thank you, Your Honors. With respect to the Collimore defendants, it's been 4 years, thousands of pages of briefing and research, and Mr. Todd stands here before you today claiming that he still doesn't understand the allegations against him. That is case in point legal malpractice, and there is evidence that he was working beyond the scope of whatever document he provided that wasn't authenticated. His affidavit wasn't prepared, notarized, sworn to be true based on personal knowledge, doesn't indicate who he was representing. I advised him that because there were malpractice claims against him, that there was a conflict of interest. He persisted in the representation of these defendants until somehow Mr. Barlow became privy and is now seated before you, which seems odd. And then Mr. Barlow talks about some sort of golfing metaphor. My client can't golf. This isn't about sports metaphors. This is about a client who wasn't being treated better than anyone. He was being kicked while he was down. The salt was being thrown in the wound, and he wasn't being treated better than anyone. He was, in fact, being treated worse because they gave a handicapped apartment to someone who was not handicapped 4 days before they evicted my client, who, if eviction proceedings were commenced against him, would have lost any federal funding that he had and would not have had a place to live. He would have been homeless more than the 4-day vacation he spent in a hotel. Thank you, Your Honors.
Thank you, counsel. Counselor excused, and the case is submitted. The court will take a 10-minute break.
Recess. The Honorable Judges of the United States Court of Appeals for the 10th Circuit.
Please be seated. All right, continuing our Utah theme this morning. This is 25-4050 Alpine Securities Corporation versus National Securities Clearing Corporation. And for the appellant, Ms. Fritz.
Good morning, Your Honors. Miranda Fritz. I represent Alpine. I will hopefully be reserving 2 minutes for rebuttal. This case presents a critical question concerning whether the Constitution permits significant government power to be delegated to and exercised by private entities that disclaim any obligation to abide by the Constitution, by its separation of powers concepts, or by the due process provisions of the Constitution. This implicates for this court 2 related issues. The first is the private non-delegation doctrine. And that is the doctrine that from Carter Cole on basically generally forbid government power being placed in the hands of private citizens. And as of last year, the Supreme Court has told us that that doctrine is very much alive and well. In the Consumers Research case, the court stated, in the leading case of Carter v. Carter Cole, this court struck down a statute authorizing certain coal producers to set maximum hours and minimum wages for the rest of the industry. We explained that the statute involved delegation in its most obnoxious form because it was made to private persons whose interests are often adverse to the interest of others. Alongside that doctrine is the following question. Where government power is held by private entities or individuals, can they evade the Constitution? Can they ignore constitutional constraints and protections? On that case, we've gotten very thoughtful guidance from Justice Gorsuch, who wrote the opinion in U.S. versus Ackerman. U.S. versus Ackerman is an extraordinarily thoughtful analysis of whether a private entity is functioning in a way that subjects it to being considered a government entity on the one hand, or a government agent on the other hand. So those are the issues that are before this court.
Can we, let's jump into the statutory scheme, because ultimately this case revolves around the creation and operation of the clearinghouses, right?
It does. There's a real contrast between the creation here, the statutory scheme here versus Consumers Research that I would really ask you to bear in mind. Consumers Research emphasized the fact that there were very clear congressional statements of principle to guide the FCC, and that the FCC then established the rule or formula that was at issue in that case.
But going to the non-delegation issue, the question is whether the agency ultimately has meaningful supervisory role or decision-making power with respect to the, I'm going to call the subcontractor, if you want to refer to the clearinghouses in that way. And the defendants, the SEC in particular, point to 78Q D1 as basically trumping your arguments that other parts, earlier parts of the scheme delegate too much power, because under that provision, they claim
Right.
the SEC can ultimately disavow any clearinghouse rule that is not in the public interest or is otherwise not in furtherance of the purposes of the act.
Right.
What's the flaw in their response to your non-delegation argument?
Your Honor, I would say a couple of things. First of all, yes, in Horstman's in Oklahoma, and even in the Alpine case from the DC Circuit, there has been a focus on this issue of the broadest sort of agency oversight and the extent to which it can amend or modify rules of the private entity. And yes, that has been a factor that has been very much a focus of the decisions. I would suggest that the Supreme Court in Consumers Research really looks much more specifically at who the real decision maker is. I think it is a more thoughtful analysis. Having said that, here, obviously in Horstman's and in Oklahoma, they focused on the fact that the agency could amend or modify the rules of the private entity. Well, here we are, and we have a statute that says, oh, no, you can't, very specifically, that enables the SEC to amend or modify SRO rules except for the registered clearing agency. Now that speaks volumes, right? So then they respond by saying, well, there's a general provision over here that would allow us broadly to enact rules that would affect the operation.
And what's wrong with that?
What's wrong with it is when you put that provision saying you can't amend, revoke, or modify, that means something. You can't circumvent it by then figuring out another way to amend, revoke, or modify the clearing agency's rules. So in terms of how that would...
And you would rely on Consumers Research for that? Or free enterprise? What's your best case for that interpretation?
We have never, I'm not saying that that particular proviso has appeared. In the other cases that we have dealt with, there has either been the ability to amend, modify, and revoke or not. And that's really been dispositive. In this case, we know they do not have that ability. And so arguably both the Fifth and Sixth Circuits would say that's not sufficient oversight. They don't have the ability to, as the courts have put it, amend or rewrite the rules. To the contrary, all they have is consistency review. Another focus of the Fifth and Sixth Circuits. And so what we have here is an agency that cannot amend or rewrite the rules, nor may it use other sort of broader provisions to try to accomplish exactly that result. And so what we have is HISA 1, Horstman's 1, where that was held to be a private non-delegation doctrine because of lack of oversight. But as we've moved forward, Consumers Research was so focused on who makes a decision and whether private individuals and entities have been given that enormous power. Bear in mind, what we're dealing with here is Congress said there should be established, the SEC should establish a national market system. The SEC then takes that enormous power conferred on them by Congress and hands it off to a private entity that is in every respect the echo of what happened in Carter Coal. Bear in mind, these individuals consist of J.P. Morgan, Goldman Sachs. The board of DTC is purely private interests operating to control access to the market. In the broadest sense, that has long been considered impermissible, and for very good reason. The constitutional, the governmental power that we allow our government to deploy is intertwined with protections that are built into the system. Accountability on the one hand to the president, to the executive, due process on the other hand. And we have argued in our briefs, and again, I think Justice Gorsuch, in his Ackerman opinion, does an excellent job of discussing the fact that you can't rip the power away from those protections. We are subject to a private entity that thinks that having a dispute adjudicated by its own board is perfectly fair.
Well, but you've now had the opportunity to appeal that to the SEC, which will conduct its review of the proceedings below.
Well, I would point out that
Just because there's a board on the first step doesn't mean that there's, that there's, it's impossible to make a bias claim to the SEC if you wish and demonstrate why there was bias in this case.
bear in mind, the SEC's review of DTC action is limited to whether it acted consistent with its rules. It is an extremely narrow review. I would also point out that in the brief that was filed in this case, there was, I think, a striking effort by DTC to really paint Alpine in the worst possible light. 6 pages were devoted in the brief to arguing the underlying case with lots and lots of vitriol thrown in. On the very first page of their...
Well, setting that aside, you successfully obtained a stay of enforcement of that, and can't you make these arguments to the SEC that the adjudication was biased? Because
No, I mean, this sort of goes to Thunder Basin factors and whether this due process issue is properly considered. Our argument is under Axon, the Supreme Court specifically said issues about an illegitimate decision maker are among those that don't require that you go through the administrative appeal system.
well, you can appeal the decision the SEC makes to a circuit court. And make those
Eventually,
arguments,
yes.
correct?
But please understand, and the DC Circuit in the Alpine case truly focused on this. The damage that has already been done at that point can't be undone. It is only by virtue of some very unusual circumstances that Alpine stands before you now, still able to present these arguments to the court.
But as to you, as to Alpine, the damage can be undone by a victory at the SEC or the circuit court.
I would argue the damage can never be undone. We've gone through years of this. We have had to go through investigation, prosecution.
But that's true of any litigation.
But again, the DC Circuit and other courts have looked at that and said, where they have the unfettered authority to do this, after the fact review is not good enough. As they said in Horseman's, the horse is already out of the barn. I would point out that the SEC has issued a further decision in our case. And I would just point out that it is DTC that they take issue with in terms of whether they're abiding by any cognizable rules. I would like to reserve time.
You may, thank you. I'll give you a few more minutes since we took your time. All right, I think you are splitting.
Yes, Your
And
Honor.
going first is Mr. Harris.
Yes.
You may proceed.
Thank you, Your Honor. May it please the court, my name is Mark Harris, and I represent the National Securities Clearing Corporation, the Depository Trust Company, and the Depository Trust and Clearing Corporation. I'm going to be splitting, as Your Honor said, my time with counsel for the government.
You want 50-50?
Sure, Your Honor. Since the founding, the securities industry in this country has been self-regulating, meaning that it sets and enforces its own rules, including the rules for membership. And clearing agencies have always been private entities, as they are now. Alpine is effectively arguing that NSCC should be treated for constitutional purposes as if it's part of the federal government, or if it's not, that it's been unconstitutionally delegated federal power. That position violates longstanding precedent, and it's wrong. Let me go through the arguments that I think you just heard from Ms. Fritz. So the main argument, I take it from them, concerns the private non-delegation doctrine. There are two branches of that argument. One of them is rulemaking, the other one is enforcement power. And as Judge Timkovich said, the standard really from the Carter-Cole case, from the Sunshine Atherkite case, the Atkins case, is whether or not the agency is exercising, I think the language of the cases was surveillance and authority, what we would call supervision and oversight. There's no question with regard to rulemaking that there was supervision and oversight. The SEC approved these rules. In fact, the SEC basically invited NSCC a few years earlier to modernize their capital requirements. In terms of what the SEC did in terms of approving its rules, there were two powers that the SEC employed. The first one is consistency review. What you heard from my friend on the other side is that consistency review is somehow inadequate. The Oklahoma 2 case from the Sixth Circuit, which just came down, that was the decision on remand from the Supreme Court after the consumers case, I think has a very, very powerful way to put this. Judge Sutton, speaking for the court, said that to criticize consistency review is to search for clouds on a cloudless day. There's really not much that could be better than consistent review. The test is whether or not what the SRO, the clearing agency, did is consistent with its rules and consistent with the statute. That's pretty much the whole standard. There's not much more that what one could ask for. In fact,
But there are, the argument is if it's consistent, the agency has to approve the rule, and the statute further takes away the power to modify or abrogate the rule, right? So that looks like de minimis oversight. Their argument is it's minimal or inadequate oversight is what Ms. Fritz said.
So that's the second power, Your Honor, which you referred to earlier, which is that the SEC has the power to prescribe rules and regulations for the clearing agency, even though it doesn't modify the rules directly. In the case of a clearing agency, what it can do is it can tell the clearing agency, this is how you have to operate.
And
that includes
that's your 78Q argument.
Exactly, Your Honor, yes. And in fact, that is what was used. That was what was used here in terms of NSCC's, as I said, the SEC's original invitation to the agency, to the SRO, to the clearing agency, to issue the ENC rule. In fact, I would argue, if anything, that this is a reflection. The fact that the standard is different is a reflection of the fact that clearing agencies are private organizations. If it were closer to a governmental organization, closer to being an arm of the government, so to speak, maybe one would expect that there would be a little additional power to go modify those rules directly. The fact that there's some distance and that what the SEC does is says, this is how we're going to tell you to operate, this is part of regulation, this is what you need to do, but doesn't modify the rules directly, it gets to the same result. It's a reflection of the fact that the clearing agencies are themselves private. But there's no reason to think that it can't do every single thing that it would be accomplished if it was direct modification of the rules.
It seems like an odd way to structure the setup, because it seems like they can't modify a rule directly. It seems like, if it's consistent with existing policy, they have to approve it. If the SEC thinks the existing policy is inadequate or needs to be changed, they have to then later, instead of dealing directly with the rule, they have to allow the rule to go into effect and then have a notice and comment proceeding to then change the basis of the existing rule to make it inconsistent with current, or, the new SEC policy.
Right, I don't think this signifies that there was, on Congress's part, really any different attitude toward the leeway to be given to the clearing agency. I think it's a function of the fact that the statutes were passed at different times. The Maloney Act was passed in the 30s, and it did not cover clearing agencies. Clearing agencies weren't added to the securities laws until 40, 50 years later. And at that point, it just adopted a different mechanism. The 78Q mechanism is just as powerful. And we gave examples in our brief of situations where the SEC has done exactly this. The SEC has said, go issue rules that would go do the following. There's no argument that the other side has been able to.
Have they ever used that process, 78Q, to modify or rescind a clearinghouse adopted rule?
I'm not aware that it's happened. Part of the reason why we would argue is that most of what the clearing agency is doing, especially in this regard, it's really its own membership rules. What we're talking about here are its own membership rules. It's acting as a private organization, deciding who can belong to it and who can't. And there's regulation. I think what we're hearing from the Alpine side is some kind of argument that regulation somehow turns something into a governmental actor. It's quite the opposite of that. The fact that there is regulation of the clearing agencies is a reflection of the fact that the clearing agencies are not part of the government. They're private organizations. All that Congress did.
Well, I know that's why we have a private non-delegation doctrine, right?
Yes.
Yeah, and I know the SEC will tell me if they've used the power before, but if not, it seems odd that if the SEC has this power to manage the clearinghouses, that they've never exercised it.
I'm not sure there's ever been occasion or a need to do it. In this, for example, as I mentioned earlier, this very rule, the ENC rule, happened because in 2016, the SEC directed the clearing agencies to consider whether or not higher capital requirements and other things would be needed. And in fact, in the rule that the ENC rule itself, which the clearing agency proposed, it cited that direction from the SEC as the basis for what it was doing, and then it was approved. So there's just no evidence here whatsoever that if the SEC didn't approve, if one goes through the SEC's actual approval of this ENC rule, there's nothing in that long discussion. It's not as if the SEC just says, well, this is consistent, we can't do anything about it, we wish it were different. It's a long, detailed analysis that explains how all of it is consistent, not only with the SEC, with the Securities Act, but also with the SEC's own regulations. I think what Judge Sutton points out is that with a statute that's been around for a long time and with a robust system of regulation as we have in the securities field, it would be very easy for the SEC, if it wanted to have all kinds of regulations that it could pass covering certain areas and certain activities. There's no danger here that this is a runaway clearing agency doing what it wants to do, and the SEC has to just shrug and say, well, we have to put up with this until we can get around to fixing it. That's not been the relationship. There's no evidence of that whatsoever. I want to quickly address, because I think counsel on the other side sort of mixed together the enforcement side of this with the rulemaking side, because I thought that their principal contention was not really about the rulemaking, but was that they were getting essentially the death penalty imposed against them, a cease to act, and there had been no governmental review of that. As I think the panel mentioned earlier, the fact that there's now been, the SEC's agreed to review to grant the stay, and there will be
Although if
appeal.
they hadn't gotten the stay, they'd be out of business. It is death penalty. It's the death penalty. You got a reprieve of execution,
But I think the point here is that they're bringing an as-applied challenge. Their whole complaint, the whole essence of their complaint was, there's a sanction that will be imposed against us, and the government played no role in it. That's obviously not true anymore. The government will play a role in it. The SEC will review this. They have the stay, so they don't have any ground really then to complain at all. It's effectively moot, that argument.
I know, but their argument's more to the structural process here, not just the way it's been applied to them. You know, and I know it's an as-applied claim, but their due process claim, isn't it a structural attack on the board's hearing process?
I think it's only a structural attack. It's only attack at all on the composition of the panel, things like that. And as Your Honor mentioned, they have a chance to brief that. They already have briefed that to the SEC. The SEC is completely capable of addressing that. I think
You wanted to share your time?
yes, I did. Yes, thank you, Your Honor.
Always risky. Right, Ms. Tan. I'll give you a few more minutes.
Good morning, Your Honors, and may it please the Court. Caroline Tan for the United States. I wanted to start with the rulemaking provision since it was the focus of your questioning earlier.
Move the mic a little bit. We're getting some feedback here.
Is that better? Is that
I'll
better?
keep going.
Okay. I guess two fundamental points on this aspect. The first is that nothing has actually happened to Alpine, and that's because of the SEC say-so. The clearing agencies initially rendered a decision that said, we don't want to provide these commercial services to you anymore. We think you violated our rules. If the clearing agencies were the ones really in charge, they would have stopped providing these services over a year ago. But that hasn't happened, and that's because of the SEC say-so.
We're still getting some feedback. Maybe lower the mic a little. Or push it.
Okay. Is this better?
Yeah, I think you're too close to it.
Okay. I apologize, Your Honors. Thank you.
There you go.
I hope you...
And slow down just a little
Okay.
bit. I'll give you extra time.
Thank you. The point I really wanted to make was that nothing has happened to Alpine because of the SEC say-so, and with respect to the private non-delegation doctrine, that's what ultimately matters. There's, the SEC review itself has also been very robust. When they ordered the full stay, they ordered 6 additional questions for the parties to brief about the underlying dispute in this case and the extent to which, the clearing companies had adequate capital during the relevant period. With respect to the rulemaking provision, 78Q1, so 2 points there that I think are really important. The first is that Alpine has not disputed the legitimacy of this rule. Their entire dispute is only about the application of that rule to them, whether they should meet this higher threshold or this lower threshold. So there's no actual argument in this case about the way in which the SEC approved this particular rule. The second is that 78Q1 is just as sweeping in all constitutionally material respects as the add to, modify, and delete language that Alpine, focuses a lot of their argument on.
Has 78Q ever been used to modify or rescind
Yeah.
clearinghouse rule?
Yes, Your Honor. In pages 41 of the clearing agency's brief, they cite to a number of examples in which the SEC has used its plenary authority over, clearing agencies to order certain changes to the way the clearing agencies are undergoing their practice. And the text of this provision is just as sweeping. It says, no clearing agency shall engage in any activity as in contravention of such rules and regulations as the Commission may prescribe. That ultimately means that the SEC is the one that gets to decide which rules govern this aspect of the securities industry. And for purposes of the private non-delegation doctrine, that's all that matters. So even if the SEC can't modify the rule directly, they can order modification. They can fundamentally be the ones that say, this is how we think policy in this space should be implemented.
But if the commissioners thought, the 10 million threshold's too high, we want it 5 million, how would they accomplish that?
Well, that's actually before the agency right now. It's part of the order of, the grant of the full stay. They've said, we would like more information about this particular rule, about the amount of capital that Alpine had in its reserves during the relevant period, and the extent to which, the higher threshold or the lower threshold should apply to Alpine. So that's something the Commission's actively reviewing at this moment. I believe Alpine submitted its brief to the SEC last week.
Anyway, I'm not sure you answered my question. The 10 million was consistent with policy according to the SEC when they reviewed the rule. Let's say the SEC now wants to, after complaints, they want to reduce it to 5 million. Alpine has hired good lobbyists and they want to lower it to 5 million. How does that happen?
I think the administrative dispute would be where the parties litigate which rule should apply to them and whether Alpine, had sufficiently met the requirements to
Well,
change
can the SEC order the clearinghouses to promulgate a rule that lowers the dollar threshold?
The SEC can promulgate its own rule that does that directly.
But it can't tell the clearinghouse to do so.
I think the SEC could, under 78Q1, they could say, you have this rule, we would like you to change it, we order you to change it.
What if they did not?
What if the clearing agencies deny it? I don't.
Do you have any power to force them to promulgate a rule?
The SEC has a number of, supervisory powers over the clearing agent, including that they can deregister clearing agencies if they so choose. But I think under 78Q1, the SEC can promulgate a rule that says we actually think, this is the way the capital requirements.
So if you clear away all the debris on the delegation issue, the answer is 78Q is the trump card for that eviscerates all of their claims.
That's correct, Your Honor. And I think, since we're speaking about trump cards, the other one is that nothing has actually happened to Alpine in this case because of the SEC say-so. To the extent they continue to dispute the disciplinary procedures or the disciplinary sort of process at issue here, they have gotten all of the government review that is consistent with the private non-delegation doctrine.
Isn't it true they would have gone out of business but for your stay?
I'm not sure we necessarily would agree with that. We do think there are some distinctions, but the SEC has said, we think you've sufficiently demonstrated irreparable harm. We're going to take a closer look, and we are going to both grant you the administrative stay, which has been, in place since the inception of this particular litigation, and also now full stay reviewing the underlying merits. If I could just
go ahead.
Say one thing on.
You can go up to 3 minutes.
Okay, thank you. Thank you, Your Honor. Because there was some discussion about the bias claim, I did want to take a few moments to talk about that. Alpine's complaint themselves only pleads this particular claim as one about the vagueness or the propriety of the clearing agency's rules. And so the way they have brought this claim has been one about the way in which the disciplinary procedure proceeded. And has also focused on the application of the Fair Procedure Requirement in the Exchange Act. Those are all the kinds of things for which the SEC's expertise can be brought to bear. Those fairness claims have actually been presented to the SEC in the current administrative proceeding, and should Alpine still be aggrieved by the end of the administrative process, they can seek judicial review in the Court of Appeals. All this just shows you why the district court correctly dismissed that claim for lack of jurisdiction and correctly applied the Thunder Basin factors. I'm happy to answer any of the questions the panel may have, but if not, we ask that you affirm.
Okay. Thank you, counsel.
Thank you.
And Lisa, could you give Ms. Fritz 3 minutes?
Thank you so much. I'd like to respond to Your Honor's question, and the answer, I think, clearly is no. They could not require that the 10 million E&C requirement be dropped. We have cited in our brief not just the logic of it, not just the fact that that parenthetical that says in the statute you may amend, revoke, or modify, parentheses, except regarding the clearing agencies, that parenthetical strongly says you may not amend, revoke, or modify. You can't circumvent it. We have cited in our brief Cherokee Nation that says if you try to pass a reg that is inconsistent with a statute, it is void. Now,
Could they use 78Q to promulgate an independent rule, $5 million rule?
I don't think so. I don't think that gives them the power to do what they can't do directly, to amend, revoke, or modify an existing rule. Now, they can pass sort of rules that might relate generally to things that don't contravene existing NSCC rules, but they can't undermine them and undo them. The other point I would like to make is we didn't even get to really the issue in U.S. versus Ackerman about whether if they are permissibly exercising governmental power, are they subject to the Constitution? In this case, the district court and DTC have doubled down on the LeBron test as being the test for state action. But in the midst of this case, the U.S. has changed its position. And I really ask this court to look carefully at that change in their position. No longer do they maintain that LeBron is the only test. I would ask the court to consider that and consider it in the context of Justice Gorsuch's analysis in Ackerman. It is not that mechanical a kind of analysis. As Justice Gorsuch says, we cannot evade the Constitution and its requirements simply by deploying a corporate form. Unless
This is going to your appointment power theory?
Yes, yes. And since we hadn't talked about that before, the LeBron issue I think is very important for the court, particularly given the government's change in position and the fact that the district court here relied completely on the idea that LeBron is the only test that would apply.
All right, counsel, thank you. You're excused. We appreciate your coming to Denver with us today, and the case shall be submitted. Final case this morning is 25-6046 Simmons versus Shobert. And you're splitting arguments. Okay, Ms. Faulkner.
And our goal is 10 and 5 on how to split it. Are you ready for this?
Proceed.
I'm sorry. You may proceed.
Good morning, Your Honors. I am Stacy Hawes Felkner, and I represent Appellant Claude Shobert, who is a retired Oklahoma City police detective. I will be splitting my time with Katie Goff, who represents the city of Oklahoma City. This case arises out of a December 30th, 1974 murder during the robbery of a liquor store in Edmond, Oklahoma. A store clerk was killed during the robbery, and customer Belinda Brown was shot in the head but survived and later testified against Mr. Simmons. The robbery and murder occurred in Edmond, not in Oklahoma City, and was investigated by the Edmond Police Department. Oklahoma City Detective Shobert's involvement in the case was, at most, setting up 2 lineups at the Oklahoma City Police Department on February 7th and February 8th, according to the summary judgment order, page 2. Shobert filled out a form documenting the February 8th lineup, which indicates Ms. Brown identified Simmons, and it is undisputed that he provided this report that he wrote to Edmond Detective Anthony Garrett. Detective Shobert never talked to the prosecutors about this case and was not asked to testify at either the preliminary hearing or the trial.
Is that in the order? What you just said, that he was never asked to testify, never talked to the prosecutors?
That is not in the order. That is what he testified in his deposition.
Okay. And the reason I ask is this is a very short order, And basically, your first two sentences encapsulated all of the facts announced by the district court
Yes, Your
in
Honor.
its order.
And that, I think, is the problem in this case. But Ms. Brown testified at both the preliminary hearing and the trial that she recognized Simmons from the night of the murder and that she had identified him in 2 lineups. She has never recanted this identification and has never testified she was coerced or encouraged or told by Shobert or Garrett to identify Simmons.
Okay, let me ask you a question. So we're talking about more facts. Generally, we don't talk about facts that aren't in the district court's order. And so you would need a basis to argue about facts to go on, you know.
And I think the basis here is what you discussed in Works versus Buyers, that there's 3 reasons you can look at. You may review the factual record de novo when the district court fails to identify the particular conduct of the alleged constitutional violation, which I think we clearly have here, since he didn't talk about the individual constitutional violations. He didn't talk about the facts related to each one. And then also, the district court committed legal error on the way to a factual determination. And I think we also have that here because Shobert's position is that you should review the factual record de novo because the district court incorrectly placed the burden of proof on him when determining whether Brown was coerced, whether her testimony was coerced. And in Works, you said that by shifting the burden to buyers or to the defendant, that is legal error en route to a factual determination.
Well, how do we know that the district court shifted the burden? The district court just said all the facts are disputed, a jury's got to decide it. Done.
Well, I think then if you don't accept that, then I think you go back to the first statement that the district court failed to identify the particular conduct of the alleged constitutional violations. I think it would have had to say a jury could find Shobert did X, Y, and Z before it could go on to whether those constituted a constitutional violation. And the district court made no findings as to what a jury could find.
Well, then maybe it should be sent back to the district court to make that determination. in the
Well,
first
I
instance.
think with relief to what respect this court should grant, you have 2 options. You can conduct the some review of the record, which the court has talked about in Estate versus Valverde and Phillips versus Kruger. You can conduct the cumbersome review of the record that the district court failed to conduct and determine what facts a reasonable jury could find, and then about Shobert's actions, and then determine if those actions violate clearly established law.
And that's what you want this panel to do?
I think that is what the court should do because you can go through, all the facts are in the record, even though they're not in the district court order. And I think when you go through those facts and how little involvement Shobert has, it will be clear that he is entitled to qualified immunity on each of these claims.
So you would have us, I guess, look at the summary judgment motions and attachments for that determination?
Yes.
Okay.
Look at the record as the district court should have and didn't. But I think this would be the appropriate route in this case because, as Simmons has stressed, this is a case where a quick resolution is important. However, I think your alternate route is to remand the case to the district court to perform the analysis it should have performed before and actually address the issue of clearly established law. And this is the approach the court took in Ellis.
Well, I mean, the district court didn't address either prong.
That's true. The district court, here we have a case where the district court did not address either prong. What the court should not do, as the Cox versus Glanz makes clear, is simply accept Simmons' argument that because the district court did not address qualified immunity, this court has no jurisdiction to review the case in an interlocutory appeal. This court, the court tacitly adjudicated Shobert's qualified immunity defense because it didn't rule in his favor, it simply ruled nothing. But Cox specifically criticized this approach because the availability of the qualified immunity defense, which has the potential to spare a public official the burdens of trial, should not turn on whether the district court addresses the defense or fails to do so. If a district court can effectively deny qualified immunity and preclude interlocutory review of the denial by simply refusing to address the issue, then the protection of the qualified immunity defense is intended to provide becomes illusory. And Simmons repeatedly argues that the court should decline jurisdiction because Shobert is refusing to accept the facts found by the district court. But the problem with this argument is that the district court essentially did not make any factual findings, as you have stated. It found that Shobert contacted Garrett about setting up a lineup on February 6th, conducted 2 lineups on February 7th and 8th, documented the February 8th lineup and gave that to report to Garrett, and that his last reported involvement in the case was February 10th, when Garrett went to OCPD to pick up other reports. Any actions purportedly taken by Shobert after February 10th, or even on February 7th or 8th, outside of the lineups himself, are based on nothing but supposition and speculation.
Well, if we do our de novo review, we're going to have to evaluate whether there's clearly established law that would, let's just assume for sake of argument, we thought there was a constitutional violation plausibly alleged or supported by summary judgment. What's your position on clearly established law?
My position is that the law is not clearly established on any of these claims. With respect to Brady, the most important factual finding that the district court made was that no one is able to confirm whether the documents in the current district attorney file for Simmons' criminal case are the same documents that were in the file at the time of the original trial. I mean, Robert Milfeld, who was a prosecutor at trial, testified he didn't know, and Murdoch, who was a prosecutor at the preliminary hearing, said, I kind of think it was not there, but that's just supposition on my part. So this finding forecloses any claim on Brady, because if no one can testify that it was in the prosecutor's file, by definition, nobody can testify it was not. And although the district court failed to address the elements of a Brady claim, at a bare minimum, you would have to have a threshold determination that the allegedly suppressed evidence was not given to the prosecutor by the police. If you don't have that, then you don't have to go further and determine whether Detective Shobert knew the contents of Garrett's report, whether he had a duty to make sure the prosecutor received that report, whether it was reasonable for him to rely on his training and turn it over to the lead detective and assume it would get to the prosecutor. With respect to the fabrication claim, I think that this court has never found a fabrication claim as speculative as the one here. In Pierce, you had DNA evidence. In Bledsoe, you knew it was fabricated because there was testimony, a suicide note saying, I sent an innocent man to prison and the police made me do it. Pierce and Bledsoe look at Pyle versus Kansas, but you also had the affidavit there from a witness who gave false testimony that he had been threatened. And we just don't have that here. I will now let Ms. Goff address municipal liability unless you have any other questions.
Thank you.
May it please the court, Katie Goff for the city of Oklahoma City. I will start the city's argument with the threshold issue of pendent jurisdiction and then move more specifically into municipal liability. Based on your questioning of Ms. Felkner, I would concede to you that the city's case and the pendent jurisdiction over the city's case is absolutely dependent upon whether or not you review Detective Shobert's case for qualified immunity and if you grant qualified immunity to Detective Shobert. In the event that you review Detective Shobert's case for qualified immunity and grant him qualified immunity based on a finding that there was no constitutional violation. I believe the case law is clear that in that instance you would in fact have pendent jurisdiction over the case against the city. If there is no constitutional violation, there cannot be a Monell claim because you cannot have a policy as a driving force behind a constitutional violation that does not exist. Those issues are inextricably intertwined. Where it becomes more tenuous, of course, is if you make a finding that Detective Shobert is entitled to qualified immunity based on the law not being clearly established. In the event that that occurs, the city would posit that those matters are still coterminous with one another. They are bound by the same set of laws and the same set of facts. So the review that you would give to Detective Shobert about whether or not the law is clearly established, those are the same facts and the same law that you would use to determine whether or not the city had a policy, and everything that Monell tells us and its progeny tells us a policy can be that caused the constitutional violation. And moving specifically into municipal liability in that case, in the district court's order against the city of Oklahoma, or related to the city of Oklahoma City's motion for summary judgment, the city has a similar argument to Detective Shobert, which is that there simply wasn't an analysis. However, for the defendant city, the court did find that there is no evidence of what the city's policies and procedures were because there are no written manuals. He made a specific finding that there are no officers available to testify about what the city's policies and procedures were. And if you review the record for qualified immunity, you will find out that Detective Shobert testified he was trained how to conduct lineups, he knew that he had to disclose exculpatory evidence under Brady, that this was a City of Edmond investigation, and that he knows that the city had policies and procedures. He just doesn't know what they are. In the event that a movement in a dispositive motion makes a finding makes a showing that there are no facts, as the city did in this case, as the district court found, the burden, according to this court in the Schneider case, is discharged from the moving party. The city made a showing there were no facts. Thus, there is no municipal liability. And with no facts, the plaintiff cannot carry his burden of proving any action by any policymaker, by any training officer. There simply is no evidence available in the record to support that case against the city, and the city would respectfully request that this court reverse the finding of the district court related to municipal liability. I would reserve the rest of my time for rebuttal for Ms. Melkner, please.
Thank you.
Thank you.
Ms. Wong?
There's a button somewhere.
Good morning, Your Honors. My name is Elizabeth Wong, and I represent the plaintiff, Glenn Simmons. Glenn Simmons spent over 48 years in prison for a crime of which he was absolutely innocent. He was found innocent by an Oklahoma court. He received a declaration of innocence in 2023. We filed this lawsuit shortly thereafter. The defendant's appeal in this case revolves entirely around its version of the facts, whether they're arguing over whether we've provided sufficient evidence to show constitutional violation on Brady, on fabrication, on the Fourth Amendment claim, or whether they're arguing about whether the law was clearly established in 1975 that a police officer could not make up that a witness said that she identified our client when she actually identified two other individuals.
That's not in the order, though.
It's not in the order, but let me address the concern about the district court's order. The district court's orders were short. I think a charitable reading of them is that the defendants had not met their initial burden at Rule 56 to show that there was no genuine dispute of material fact. But the way that this court does the analysis in a case like this is, first, we look at what is the universe of facts that the district court has identified as creating a dispute of material fact, and then the court can supplement that as the panel in Kruger versus Phillips did, as the panel in Estate of Booker versus Gomez did, with a de novo review of the record to look at what are the facts that the district court likely assumed.
Okay, so you agree that this is a proper case for a de novo review or a remand for the district court to expound on the proper universe of facts?
It's within your discretion to do either one, whether it's to remand to have the district court spell out what exactly are the material disputes or genuine disputes of material fact, or for you to conduct a de novo review. But let me be clear about what that de novo review is. The de novo review is to look at the record and view the facts in the light most favorable to the plaintiff and all reasonable inferences therefrom, to figure out what are the facts that the district court likely assumed in denying summary judgment on the basis of qualified immunity. And that is where the defendant Shobert and the city's argument fails, because all of their arguments, as we pointed out throughout our brief, depend on their version of the facts, not charitably viewing what the prosecutors testified, not crediting what Mr. Simmons testified about which lineup he was in, the fact that he was only in one lineup.
What do we do with, I mean, okay, so fair enough, he says he was only in one lineup. He also, over time, has given conflicting versions of that. What do we do with that? So do we have to assume, do we have to view his conflicting statements charitably toward him and say, well, we'll just go with the one that's best for him?
Yes. Yes, you absolutely
Okay, so
do.
he can conflict, he can have his own conflicting testimony, and we have to disregard the one that's inconvenient for him.
You have to view all the facts in the light most favorable to him, but let me be clear what the record actually shows. He never previously testified. He was never asked before, under oath, about what lineup he was in. He did testify in his own defense at the criminal trial. He was not asked any questions about the lineup. He simply testified about his innocence and about his alibi and the fact that he was at a pool hall in Louisiana on the night of the robbery and the murder. That's what he testified at the original criminal trial. With respect to the 1997 habeas proceedings, there was no evidentiary hearing. There was no declaration or affidavit submitted from him. And the one thing that they point out is the briefing that was written by his attorneys in the state post-conviction in the Oklahoma courts, and a note that he wrote to his attorney where he's talking about what the report shows. Now, Mr. Simmons' memory, both at the...
If I could interrupt there and apologize, but there was also a federal habeas proceeding. I don't know what the answer to, but a panel of this court denied habeas relief on an actual innocence claim because it said there was no evidence that there was a Brady violation. What do we do about that?
That has no collateral estoppel effect. The defendants have not argued, and they expressly disclaim in the reply brief, arguing that that has any collateral estoppel effect. That was known to the Oklahoma courts in 2022 and 2023 when Mr. Simmons litigated his state post-conviction. And the record here is different than the record that was before the court at that time, because again, there was no evidentiary hearing, there were no affidavits and no declarations, and most importantly, it's not just about Mr. Simmons' testimony today, but it is about the testimony of the two prosecutors that we have in this record today. And what those prosecutors state, and again, this conflicts with the defendant's position here in their briefing and an argument, Mr. Murdoch, the preliminary hearing prosecutor, testified at the appendix 1364 to 65 when he was asked, do you think that you had this report in 1975? And he said, I don't think so. The trial prosecutor, Mr. Milfeld, when he was asked in his deposition about whether or not he had the exculpatory lineup report, he talked about how he was shown it for the first time in the evidentiary hearing in the state post-conviction in 2022. And he said, I told the post-conviction attorney at that time, I don't think I've ever seen that before. Those statements have to be credited.
So do those have to be credited as, in your view, as I've never seen that before? Or are they credited as, I don't know if I've ever seen that before? I mean, those are two very different things, aren't they?
Well, let me be precise.
I mean, from an evidentiary standpoint?
Let me be precise. Mr. Murdoch's testimony was, he was asked the question in his deposition, and based on the preliminary hearing transcript and what you know and your knowledge of your own obligations to disclose Brady evidence at the time, you don't believe that you had a copy of the lineup report at the time of the preliminary hearing, right? Witness, I don't think so. That's at appendix 1364 to 65.
I just heard too, I mean, I get the testimony, and I don't know what the import of it is, I mean, yet, but I'm just, go ahead. I mean, I don't want to, it's not doing anyone any good for me to joust with you about facts, but I'm just trying to get a handle on how you think we have to view the evidence if it's unclear. I mean, what's clear is someone asked him if he believed he'd ever seen that, and he said, I don't think I've ever seen that.
No.
Both of those, the question was hedged and so was the answer. And I just don't know how we treat something like that.
He was also asked a series of other questions and earlier on other pages of his deposition that we said in our response brief about whether or not he understood his Brady obligations at the time in 1975, whether he would have turned over this report, whether he thought, looking at it now, that the report was exculpatory. And let's not forget that the trial prosecutor, Mr. Milfeld, testified at the evidentiary hearing that he had an open file policy. And so there's no dispute that nobody ever made anything of the fact that Ms. Brown had actually identified number 6 in the lineups, which was not the position that Mr. Simmons was in. According to the case record, which is one of the 2 fabricated documents that Mr. Shobert gave to the prosecutors, according to that fabricated document, Mr. Simmons was in position 2 on both February 7th and February 8th of 1975 in those lineups. We now have a report which says that she actually identified number 6 and number blank, and that it was the same 2 on both days. A defense attorney clearly would have asked questions on cross-examination of Ms. Brown about the differences in her testimony. They tried at trial to impeach her credibility, to say that she wasn't sure, but they didn't have this crucial document which showed that she identified somebody else entirely. I mean, you know, the question...
Where did the report come from?
Well,
go ahead.
In the 1990s, Mr. Simmons finally got an investigator to do some pro bono work for him, and he sent an open records request to the Edmond Police Department, and the Edmond Police Department produced it at that time.
What about the city's claim that there was no facts to support the Monell claim?
There's not been a single case in which this court has ever, in a appeal of a denial of qualified immunity of an officer, there's never been a single case in which this court has reached out to decide whether or not the city's policies or training were sufficient. And this case should not be the first one in which to do that. Now, there are some things that Ms. Goff said that I agree with, and many things that she said that I don't agree with. The fact is that in order for this court to exercise pendant jurisdiction, which is generally disfavored, over the city's appeal, you would have to find that we have not shown sufficient evidence to show constitutional violation on any of our theories: Brady, fabrication, unduly suggestive ID, the Fourth Amendment claim. You would have to find that there is no constitutional violation on any of them, because if there's a constitutional violation on any one of them, then it doesn't resolve the claim against the city. Now, if you decide, so they would have to win across the board on all of on the first prong of qualified immunity in order for you to reach out and decide the city's appeal. With respect to, you know, if you decide that there were some claims that were not clearly established at the time, which of course we contest, that would not resolve the city's appeal because the city is not entitled to qualified immunity. With respect to so, you know, as we've stated, that I think, you know, it's within your discretion whether you want to remand to the district court or to decide the case here by reviewing the facts. I think that given the passage of time and given Mr. Simmons' current state of health, and given that the city is not asking the court to remand either, what we would urge this court to do is to look at the record with a view of viewing the facts in our favor and figuring out what facts the district court likely assumed. And, you know, the district court's opinion, while short, did say some things which I think that the other side is not really...
Don't we have to assume that the district court considered the entire factual record that the two parties presented to him?
Yes, of course. And he clearly did. I mean, he noted what his opinion is short, but he did know what the claims were. He understood that we were asserting claims under Brady, fabrication, unduly suggestive ID, the Fourth Amendment claim. He states in footnote 3, he acknowledges in footnote 3 of his opinion that the lineup report is the one that we say was exculpatory and never provided to the district attorney, although, you know, could have been phrased a little bit differently. I think that the charitable reading of that is that he was finding that the facts, a reasonable jury could find those facts in our favor. Another example of the district court's opinion saying, finding certain facts that you have to accept in the context of this appeal is finding that Shobert testified at his deposition that he did not remember anything about this case. He did not remember any conversations with Garrett, anything about Mr. Simmons, anything about the lineups, the trial. He remembered absolutely nothing. And yet, at summary judgment, Shobert submitted a 9-page declaration from his attorneys attempting to dispute his prior complete lack of memory of the case, because I think they realized that that was not helpful to them. That cannot be credited, and under the district court's opinion in footnote 9, that cannot be credited because the district court disregarded that declaration.
Okay, so in your view, in reviewing whatever Shobert said, we would disregard the affidavit and basically say he knew nothing.
That's correct.
Okay.
That's correct. With respect to whether the law was clearly established at the time, I think, although the events of this case are probably older than many of the other cases that have come to this court in a wrongful conviction case, it was nevertheless clearly established in 1975 that a police officer could not make up evidence about who was identified in a lineup. A police officer in 1975, a reasonable police officer, would have known that you could not take information that he knew about who the witness identified and fail to give it to the prosecutor when it was completely different than what he wrote up in the case record. We also have...
And what 10th Circuit case are you relying on?
Well, there's Pierce versus Gilchrist, which of course involved events from 1986, but it cited Mooney versus Holohan, which was decided in 1935. It also relied on Brady itself, which was decided in 1963. It relied on Pyle versus Kansas, which was decided in 1942. So, of course, the language of Pierce is phrased in terms of the events that you were looking at in that case, which occurred in 1986. You were relying on cases that were far, far older. And that is the same thing that circuit courts around the country, including the Sixth Circuit and the Jackson versus City of Cleveland, have found. So it's not only clearly established by the Supreme Court cases themselves, but it's also clearly established by this court's cases, and the weight of authority also supports our position.
So do we have to, if there are documents that show that whatever Shobert gave to whoever were inaccurate, do we have to assume that the inaccuracy was a fabrication, or does there have to be more?
Well, if Simmons is saying he was only in one lineup and he was not in the lineup on February 8th, and Shobert writes down in the reports that Simmons was in this lineup and Belinda Brown picked him out, that is necessarily false. The question of his intent...
Well, that's a difference. I mean, it's not necessarily false. It's necessarily that two people are saying two different things, but we don't know why. And I guess my question is in that regard, do we have to... to construe it in your favor, do we have to presume it's false?
Yes, yes. For fabrication, you do have to show knowingly, recklessly, or intentionally, and I think that's the standard for both fabrication and Brady. But that's a jury question. The level of intent that a defendant has is a jury question, which the district court decided in our favor.
True, but you don't get to generally go to a jury just by saying it's false. Jury decide that it is. I don't have anything else to tell you about it. You have to provide evidence of falsity.
Absolutely, and the corroborative evidence is the way that the Brady claim and the fabrication claim work together. So we know that not only did he write down something completely false, but we know that he also hid this lineup report. And let me back up. It's not just about what the lineup report itself. It's not just about the piece of paper. It is about his knowledge that Belinda Brown identified number 6 in both of the lineups, and that was not Glenn Simmons. And he kept that information to himself. He did not talk to the prosecutor. He did not disclose it to the prosecutor, and he didn't ensure that anybody else knew about that either.
Okay.
Thank you, counsel. Your time's expired. We have some rebuttal.
With respect to your last question as to whether the report shows falsity, the problem here is that you cannot get from the Declaration of Innocence in the sense of Miss Brown was wrong to Miss Brown's testimony was fabricated by the detectives. They put on a witness that said, an expert witness at the evidentiary hearing explaining all the reasons that her testimony or her identification could have been wrong. But that doesn't mean that it goes back to show that Shobert fabricated it. So, thank you.
Yeah, I'll give you another minute if you had something else to say.
Okay. I think we did credit what the prosecutor said because they both said, we don't know. Murdoch said, it's a supposition that it wasn't in there. And Millfeld said at the evidentiary hearing, I've never seen this before, because they gave him 3 pages that were just that report. And then he looked at it in the context of what appears to be a DA file. And he said, I don't know if this was in the original file, but there's circumstantial evidence from the way it looks, from the hole punching. And he said, and when I saw this and thought it probably was in my file, I almost had a conniption. That's not really, I know it wasn't in the file, which is what you would need to get to Brady. Thank you.
Thank you, counsel. The 3 of you are excused. The case is submitted, and the court will be in recess till tomorrow at 9 o'clock.
Recess. It's good to see you.